Thank you very much, Justice Hedigan, for this wonderful talk. I'm sure the audience is waiting to ask questions. And now I'll invite Professor Raj to moderate the question answer session.
Hello, sir. So the first question is, what effect does Brexit have on the human rights obligations of the UK?
Well, it doesn't have any implications at the present moment because despite what you would read in the British newspapers, which continually complain about interference by European courts, and they are almost always referring to decisions of the European Court of Human Rights, which have outraged many in the House of Commons, they are not actually departing from the Council of Europe. And they've said they're not departing from it. They're departing from the European Union. And so it's a completely different body. The European Union, as you know, is now 27 countries, and the Council of Europe is 47. The only country in Europe that is not part of it is Belarus. I must say in passing, I'm hugely saddened by the decision of the British to leave. I worked closely with my British colleagues on the court, both in the registry, and my British colleague, Judge Bratza, who became the president of the court. And when I came back to Ireland, I wound up representing Ireland on the European Network of Councils of the Judiciary, and I was elected to the executive board of that body, and I worked very closely there with British colleagues. They were invariably outstanding contributors to everything. The British were able to provide huge backup in terms of reports and things like that. I don't know what we'll do without them. I think that their decision was based on an almost universal failure to understand the enormous power they wielded as members of effectively the group of three, themselves, France and Germany, who ran the European Union, and the power that they exercised there over the most important trading body in the history of the world, I think gave them more power than they had since the height of the British Empire at the end of the 19th century. To hear the UK described as a vassal state by the Brexiteers was positively laughable to those who were familiar with what actually was going on in Europe. But there it is, the decision has been made, but the answer to your question is no impact whatever.
Okay, sir. Thank you, sir. So the next question is, can the housing crisis in Ireland be argued as a human rights issue?
There have been cases that raised that sort of issue before the court in Strasbourg. Nobody, to the best of my knowledge, has brought a case against Ireland. As I mentioned earlier on, we have in our 1937 Constitution a very powerful section dealing with fundamental rights. And nearly all the kind of issues that arise in the Strasbourg court are actually capable of being dealt with and are dealt with by the domestic courts. The cases that went to Strasbourg to a great extent were ones that are not dealt with properly in Ireland, ones relating to abortion, to contraception, to information concerning abortion and contraception and other issues, so-called social issues, which we until quite recently found very difficult to deal with, but that has changed. Housing rights, I have heard people suggest that there should be a constitutional right to housing. Of course, it's a very difficult social issue because you're directing the government as to how it spends its money. But one can see the argument for it. I think that there must be, and I think there probably is, a sense in Irish people now that there is a constitutional right, and that based on the human right, to housing. And it was probably the dominant factor in the last general election and resulted in the governing party, which had been considered to have done a splendid job on the Brexit problems and the Brexit negotiations, resulting in effectively the whole agenda for the border with Ireland and its impact on the single European market being written in Dublin. Despite their having been perceived by everyone to have done a splendid job, they were very soundly defeated and almost exclusively on the issue of housing. So it's a very hot topic.
Thank you, sir. So the next question is, can the ECHR adjudicate on human rights violations committed by European countries in non-European territories?
Extraterritorial
Yes.
territorial jurisdiction
Yes.
of some kind. The court has held that the countries that have, for instance, British troops in Iraq do have responsibility for their actions in terms of the Human Rights Convention, and that they carry it to areas that they control. So yes is the answer to that question. There can be violations of the convention occurring in areas outside the territory of the state, but essentially only where they are in control of that. And a very peculiar example of that, if that's the right word to use, was a case brought against the NATO states in relation to the bombing of the TV tower in Serbia, and during that war, and there the claim was that the NATO countries were in effect in control of the superincumbent column of airspace, as we used to call it in torts, over the city, the capital city, Sarajevo at the time, and that therefore the people who had been victimized, the relations of people killed, could bring a case against the NATO countries. But the court held that that was not so, because they were not in control of the space. They were not in control of it in such a way as to impose upon them an obligation and the ability to protect human rights. Dropping bombs on people from high in the air doesn't actually give you the control over the human rights situation on the ground. But there can be extraterritorial violations of the convention.
Right, so thank you so much. The next question is, respected sir, when you sit as a judge in a court looking at a human rights issue where one party is the oppressor and the other party is oppressed, how do you objectively pass a judgment? Does human emotion come into the picture when deciding a human rights issue?
Well, I think judges, are obliged to do justice without fear or favour, affection or ill will, and in accordance with the law. But judges, like everyone else, are human beings, and they bring with them all their human background, where they come from. I mentioned it earlier how my earliest life I was helping milk the cows. That's quite an experience, actually, when you lay your head on the side of a cow and milk the cow. And it's a very interesting kind of thing to do. And things like that, I think, are part of one's background, where you came from, what your views are, probably what your religion is, if any. And so you bring naturally an element of your emotions to bear, but you must be very careful about how you bring your emotions to bear in a case, because a judge whose heart is breaking and who is not complying with the law is creating more trouble downstream for society in general, and is possibly not doing justice to the person in question. But suffice it to say that whenever a situation appeared in front of me, and I was in charge of the judicial review list for quite a number of years, in which the administrative acts of authorities would be challenged, and sometimes by people who really did feel oppressed. If I thought that there was a really unjust situation at work, I would do everything that I could to try to remedy it. And the courts are armed with very powerful weapons for doing that. And there's all sorts of ways of doing it. But one can never depart from the law. That one has to remember that the judge is an unelected person and is bound by the law. Sometimes one of your early questioners referred to the homeless situation. Sometimes in cases of repossession, where I would be dealing with maybe a large list of applications for summary judgment because there was no defence whatever to the application. Money had been loaned, secured on a property, it hadn't been paid back. Usually no payments have been made for years. In Ireland, that's the way it tends to work. And there was, I knew perfectly well, there was absolutely nothing that I could do. But I, on more than one occasion, asked the people who would generally not be represented by anyone to come up to the bench and to explain to me what the situation was. And I had people in tears in front of me at times, which was very distressing. But at the same time, it gave somebody to understand that a human being had actually listened to their story. So that's one of the ways that one perhaps does justice, even though you're not actually saving them from a house being repossessed. But on the other hand, you're putting an end to their misery and bringing a closure to proceedings which are going in only one direction. Hard situations, though. But yeah, you can't divide yourself up as a human being. You are a human being full of emotions and with your own background and feelings and philosophy.
Yes, sir. So probably we'll take two more questions. We have time for two more questions. So one student asked you for your comments regarding the plans of Poland to leave Istanbul Convention and what are its ramifications. And the Council of Europe has also raised this issue, I believe.
The Istanbul Convention you're referring to, is that the one concerning the protection of women?
I believe so.
Well, the Polish situation, if I can just approach that in a general way, because I know that there are proposals, not just for that, but for many other matters in Poland that are of the greatest concern to the European Union, and I was very closely involved in that on the European Network of Councils of the Judiciary. In fact, I co-chaired with DG Justice, that's Directorate General Justice of the European Commission in Brussels, a meeting with Justitia, which is the Association of Polish judges, and it was pretty awful to hear the assaults that are being made upon their independence, the threats made to them personally, privately, publicly, all sorts of very, very unpleasant action going on. It's as a result of all that that the European Union and the Network of Councils of the Judiciary are deeply concerned about the rule of law in Poland. The ability of the courts to actually review the constitutionality of things in Poland, of provisions in Poland, are very, very limited now. The pressure on judges through politically packed disciplinary committees, which could take action against them, even for their decisions on the basis that the decision was wrong and that that's a disciplinary matter. These are very serious developments. So Poland and Hungary are two countries that are giving the greatest cause for concern to the European Union. And the recent decision to create this massive stimulus fund may well wind up to be conditional on compliance with certain rule of law procedures. And the procedural way that that has been done has resulted in a situation where, as that money is paid out, it will not require unanimity on the part of the members of the Council of Europe, of the European Union, but a qualified majority, which is a very different thing and would result in an inability for Poland or Hungary to veto action taken against either one or the other. So there may be a chink of light coming in that direction. I certainly hope so.
Thank you, sir. So the next question is, recently around the world, we've seen multiple instances of police brutality, which led to the Black Lives Movement matter and other such movements. So according to you, what are the kind of reforms that we can initiate on the international level to curb police brutality?
Well, it has to come down to police training. From what I can see, police training in the US, for instance, where you're seeing a lot of this police brutality, is very inadequate. It certainly is nowhere near the level of training that police are given in our country, in Ireland. It doesn't last nearly as long and isn't anyway as in-depth. And I suppose the gun-toting masculist characteristics of certain sections of American society lend a lot of difficulty there. It's very sad to see what's going on in the US. I'm a great admirer of things American. I've been a student since, as I said, since 1960 of American history and politics. And I'm profoundly saddened at the state that things have come to in the US, a country that's almost deconstructing its society. And of course, this Black Lives Matter is really the latest manifestation of what has been described as America's original sin, slavery. However, police brutality does exist in many countries around the world. When demonstrations occur, it's almost inevitably the case that there are going to be confrontations between people, frequently young men on both sides, and tempers flare and things happen that shouldn't happen. It requires a very disciplined police force to keep control, and that's always going to be very, very difficult. But certainly it's a topic that needs to be dealt with. Police brutality was dealt with in a number of cases before the European Court of Human Rights. I remember a case against France in which that gentleman you saw, Jean-Paul Costa, was the French judge, and he said to me afterwards he was just so profoundly ashamed and embarrassed by the police brutality in his country, and he didn't realise it was as bad as it was. So institutions like the European Court of Human Rights are very good for bringing out these kind of situations, and have done on a number of occasions. Equally, we have rejected some cases where there have been fatalities as a result of the actions of police, where it was thought that in the agony of the moment, police had used the minimum force, and unfortunately it had resulted in fatality. So they're not always open and shut, they're not always cut and dried. There sometimes are nuances.
Okay, sir. Sir, I believe we have time for one final question. So the question is, does the German Constitutional Court's ruling against the ECB's public sector purchase program, which is opposed to the ECJ's opinion on the same, have any negative impact on how the role of supranational judicial institutions such as the ECHR itself is perceived by the contracting states?
It's a very interesting judgment, and I must say we had our own problems with the German Constitutional Court. I was the judge on the first case of Princess Sophie von Hanover versus Germany, where the Germans had come to one conclusion about the right of public figures to a private life, and the court came to a different one. And I know that I didn't actually go up to the German Constitutional Court subsequently, but some of my colleagues did, and they certainly got some strong criticism from the German Constitutional Court. So they have their difficulties with international supervision, and of course they're exacerbated by the fact that Germany is a federal state, and the federal Länder, they have very, very great power. It's not a unitary state at all, and loads of things that happen must be okayed by each one of the Länder. So that's a difficulty. I found a little bit of difficulty with that judgment when, for instance, they described the judgment of the court in Luxembourg in the case that they were dealing with as being incomprehensible. That to me is extraordinarily injudicious language. It makes no sense, because if you don't understand a court's judgment, then you should ask them, what does it mean? The ability is there to do that. So there were a lot of things that were rather disturbing about that judgment. But there has been also a lot of attempts by the German Chancellor Merkel and her government to damp down fears that it may interfere with the workings of the European Union or any other part of the Council of Europe. And I know that the ECB have recently justified one of their actions in relation to borrowings. That was the key question for the German Constitutional Court. And they may well go down that road of doing more justification for what they're doing, and that would perhaps meet the fears of the German Constitutional Court that the European Central Bank was going beyond its jurisdiction. But I think you'll have to watch that space. But the German Constitutional Court certainly has some very, very strong views. And it's very interesting that it's made up of a lot of professors of law as well as practicing lawyers. And I often wonder sometimes, you have professors versus the practicing lawyers, and the two bang their heads against each other, and one is saying you can't do that, that doesn't work on the ground, and the other says you must do that because it's not logical to do otherwise. So those are very interesting dichotomies that require resolving, and I greatly enjoyed those when they occurred in the European Court of Human Rights in Strasbourg.
Thank you. I think we've had to bring the question and answer session to an end. I think I wanted this talk to go on, and I didn't want to put an end or to bring the flow of questions to an end, because I could see the interest that so many students have in this topic of today's talk, and the fact that they found a person who could respond to their queries. But the clock goes ticking, and this wonderful session also has to come to an end. However, I'm very optimistic that Justice Hedigan, you will oblige us by coming back to speak to our students and give us the opportunity to gain from your wisdom and experience. As we come to the end of this session, I have the privilege to thank everyone who has contributed to the success of this lecture. We're extremely grateful to you, Justice Hedigan, for accepting our invitation to address the audience through the online platform and connect to the young minds at Symbiosis Law School, Pune. Thank you, sir, for talking to our students, and I'm sure they go back enriched, and I'm also sure that you have kindled a light in the minds of many here. The COVID pandemic has created a havoc, but at the same time, it has taught all of us that although movements have come to a near stop, we can still get connected, and in the world of technology, it has provided a means of being anywhere across the globe and be connected to people from any part of the world. We look forward to hearing you many, many more times, and we also look forward to hosting you again at Symbiosis Law School, Pune, once the pandemic is over. I also take the thank you, sir. And I also take this opportunity to place on record that we are happy to collaborate with IALS to host this IALS Distinguished Guest Speaker Program, and we are definitely benefiting and gaining a lot from this collaboration. A very big thank you to Dr. Gurpur for the wonderful leadership that she provides to Symbiosis Law School, Pune, and ensures that the best is brought to the law school. Thank you very much, ma'am, for all this. The international cell at Symbiosis Law School, Pune, along with Skalsar, requires a special mention. And I also thank you very much, Professor Raj, for moderating the question and answer session today. Our IT team deserves a special mention for all the technical support that they have provided. And last but most important in any event is the audience. We have had more than 350 members in the audience today, and I must thank each one of you amongst the audience for joining us and encouraging us by your presence and questions and giving us that encouragement to organize more such event. Thank you one and all, and thank you very much, Justice Hedigan, once again. Thank you.
Thank you very much.